Good morning. Are you Leonard Gillery? And Mr. Gillery, in cause number 22-40982, on probation for unlawful possession of a firearm by a felon, that probation started last June of 2024. It was a 7-year deferred probation. Motion to revoke that unadjudicated probation has been filed. Looks like the primary two allegations are, one, that you have allegedly committed the offense of aggravated assault with a deadly weapon, June 19th of 2025, and also evading arrest or detention with a vehicle on that same date. The evading, has it not been filed or indicted? Okay.
Was it with a vehicle?
It was with a vehicle. That's at least what the administrative hearing says, but
I don't know that it was with a vehicle.
I haven't seen anything about the evading.
I think
it was only the.
My recollection was that it was evading on foot. I'm happy to explore it and check.
that's okay. Let me look at this as well. And so I'm going to take judicial notice of the court's file in each case. The new alleged offense of aggravated assault has been indicted in cause number 25 DCCR 0902. There's a $200,000 bond set in that case, and there's no bond in the motion to adjudicate. Mr. Lewis has filed motions in each of those cases asking, one, that I set a bond in the motion and that I reduce that bond. And the new allegation, I'm printing out real quick the PC. I'm going to take judicial notice of that. Give me just a second to review it as well. Mr. Coleman has filed a response reply to those motions to reduce, and I have reviewed that as well. Give me just a second.
So she specifically remembers those things. She also told you that one of the reasons why she remembers a specific time period is so she remember that the defendant had been released from jail early. There are 16 photographs that were introduced since and it tells you the date they started detaining. So she told you, she saw this footage, of course it's her, she said that's in the defendant's bedroom, and she told you that she was high at the time. Those pictures, and I think when you look at those,
It was on foot, yeah.
That's what I thought, Judge. It allegedly
Started on a bicycle.
Yeah, I don't know where they get the vehicle from.
Yeah, they wrote it wrong on the PC even. That's where it came from. All right, Mr. Lewis, do you wish to call your client?
Oh, ma'am, Judge, it's just an argument.
Okay, go ahead.
Judge, as far as with these motions, the motion to set bond, motion to adjudicate, of course, majority of this does deal with this new allegation. As far as the other conditions of probation, Mr. Gillery had, doing well with that. He technically was not working at the time of the offense. He had basically a reduced workload. It was a layoff, but they have been called back to come back to work. He's trying to be able to bond out so he can get back to work, possibly even hire his own attorney, or at least be able to take care of his bills and things like that while we go through this process of taking care of this case. So he definitely would like that opportunity, at least by having a bond set on with the MTRP. As far as the new case with the ag assault, understandably, it is will be considered a serious offense. We are asking for a reduction there, maybe in incorporating some bond conditions that may secure any of the court's concerns with any public or private safety, waiting for the plaintiff witness or the general public while we're dealing with this, which could include, of course, GPS monitoring with a curfew would allow him to be able to go work and be back home to at least be able to take care of these things. With his job, he would be able to afford the monitoring and GPS monitoring. He does have some support, family support. His wife is here today and has been here each time before she would come to court. And so that's what we ask for, Judge. Just, if they can get a bond that is a little more reasonable than $200,000. A bond that high, a lot of bonds from the courts It's all, a lot of them won't even touch that amount.
So what is the status of the burglary of a vehicle in Hardin County from June 8th of this year? That's an allegation in the motion as well.
As far as I know, it hasn't been accepted or they've been going to court on that, my understanding. So the main issues that we were dealing with, of course, is what was here.
Well, that's, obviously that one is also important to me because that would be another felony allegation while he's on this probation. Let me see if the administrative hearing has any information on that.
Yeah.
So when the administrative hearings are scanned in, I've noticed that some of them, it'll say see attached narrative or PC or something, and those are not always scanned in.
Are you looking at the court copy? It'll say court copy.
Okay, so the court copy should
Court
have
copy,
it.
'cause, it's not public.
Gotcha. No, no, that's perfect. That's what I needed. Give me a second. I'm gonna print this out because this is.
She said she had lots of pictures on her phone, just like any other teenager. I have lots of pictures on my phone too. I can pretty well tell Don't check your comments and shut the door. Let's think about that. Why
Mine.
Oh, I'm sorry.
So, for the record, I'm taking judicial notice again of all of the court's file attached to the administrative hearing, which was dated June 16th, 2025, which is previous to a second one that was filed with regard to the new aggravated assault case. This one includes violation that he allegedly committed the offense of burglary of vehicle in Hardin County and failed to report his arrest to his probation officer, and then GED, community service, and some things like that. Attached to it is the narrative from the Hardin County officer. Let me read that, and I'll give you both an opportunity if you would like.
You had also heard her testify that her brother and his grandparents may not like it if she went over to Mr. Isaac's house because it's extremely drama. Related to something going on. We really didn't dig into it, but you could tell that something's there. Some sort of drama is there. Is it possible that she has something against Mr. Isaac, or maybe her brother has something against Mr. Isaac? I don't know. I'm not suggesting that. But is it possible? You heard her testify that when she allegedly smoked with Mr. Isaacs, it was ridiculous. It was ridiculous.
So this is allegedly a neighbor
Is it possible that
where the allegation is that Mr. Gillery
I just don't know.
got in their car,
Sense that it could have been
tried to start it,
that it could have
and leave, that they
veered to a different?
confronted him,
No.
that he got out, walking up and down the driveway between the trailers, quote, freaking out, striking the trailers in his own vehicle. The officer also noticed kind of some erratic behavior, felt like he was under the influence of some type of intoxicant, which he denied, but it sounds like there was something going on.
And Judge, if I may, speaking with him, he said this was an episode where he was under some type of psychosis, dealing with mental health, and checked himself in for treatment shortly after.
All right, so obviously I need that information because I don't feel like if that's going on that it would be in the best interest of our community to have a bond at this time. If there's something going on, then potentially we need to have some type of evaluation done ourselves to find out what that is and get that information to me. Based on all of the allegations in the motion, as alleged, the burglary of a vehicle, the new aggravated assault with a deadly weapon, and the fact that he's already on probation for unlawful possession of a firearm by felon, which means he's already a felon in that burglary of a habitation case, I believe. That was a conviction. I'm going to find, based on all of that information, under 17.15, as well as the Constitution, that I can deny bond in the appropriate circumstances. And at this time, in cause number 22-40982, I am going to deny setting a bond in that case. And I'm going to deny the request to reduce the bond in cause number 25 DCCR 0902. And if you will get any information gathered together with regard to any mental issues, obviously that could go into play once we get to whatever point we do on what I'm going to do with the probation in the new case, and potentially for Mr. Coleman as well. If you feel like there's an issue with competency, let me know. It doesn't sound like that's the issue, but if so, just let me know and we'll get someone out there to see him as quickly. So again, you are Jarrett Matthews, and Mr. Matthews, get back to my get back where I need to be here. Hold on. It's cause number 23 DCCR 1211, and Mr. Matthews is charged with unlawful possession of a firearm by a felon from September 13th of 2022. Mr. Kimmler has filed a motion asking that I reduce his bond, and bond is currently set at
Why is a 47-year-old man
30,000. Looks like, is that correct,
105?
Is that right?
Mr. Kimmler?
I think it was one, I thought
Yeah, it was at
it's 100 is what I thought.
Same thing with the timeline from 2022.
So it was initially set at 30.
164
So let me see here.
messages, phone calls, everything. 164 15-year-old girl and her 27-year-old
100. 100.
Okay. So I wonder why.
We'll take 30, Your Honor.
normal relationship, a normal cousin relationship.
Sure you will. I'm just looking at, okay, so apparently back in September of 2022, there was a bond set, and then I guess Mr. Matthews made that bond.
Then he went into custody in Louisiana and stayed in custody.
And when he got back, it was reevaluated in a bond set at 100,000. So I have and will take judicial notice of the court's file, including the probable cause affidavit, the magistration documentation that was used at the jail, and also the public safety report. Mr. Kimmler, you may proceed.
Your Honor, I suppose the initial bond was 30,000, and then, of course, he accrued the cases in Louisiana, was in custody on the next court date, so was unable to make that. I don't think there's been any type of intervening circumstances from the time that he got the $30,000 bond and now that would warrant an increase in the bond, other than just being out of state incarcerated.
Well, that we didn't have the public safety report system back in 2022, so I'm sure the new magistration process, that magistrate looked at the several pages that are included in that.
I'll just let Mr. Matthews address the court, then, Your Honor, he can explain his current.
Raise your right hand the best you can, please, sir. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
yes, ma'am.
All right, go ahead.
Explain to the court what your current situation is as far as your living arrangements, where you would be residing, and what your plans are.
I still stay in Lake Charles with my mom. From when I bonded out here the first time, I never missed court. I never failed a drug test or any of that.
You were in custody in Louisiana for something between then and now?
I caught a charge prior to the charge I caught out here.
Okay.
This is my most previous charge,
Most recent.
You're,
most recent charge.
and what was that charge?
It was a convicted felon with a firearm charge.
Jefferson Davis Parish, right?
Yes,
And what was your sentence?
4 years. I was in the military 7 years. Nah, I have a little PTSD. I was going to mental appointments before I got incarcerated.
All right. Anything else?
It's a 4-year offer, Your Honor. He's wanting to try to get probation, so I would like to try to get him out, maybe to get established a little bit to show that if we come back on a contested sentencing, that he could do the probation. Is that what you?
Yes, sir.
Did we have a hold on him when he was in?
It's my understanding, Judge, and the reason for the offer being, obviously you see the offense date is quite
Right.
old. He should have had a hold at some point in time. I obviously appreciate his military service and will be willing to work with him on that. My problem being is that he's not a resident of this county.
Right.
Well, for
So,
Veterans Court, right? But I
Right.
think we could transfer the probation.
well, I guess I mean, if he wants a probation, that's one thing, and that's up to them to offer that. If he has been incarcerated for most of this time, then we can make that, even if we didn't have a hold. I can make a finding that we should have, and if you get that documentation on how long he was in custody there between the time of the indictment, nothing before the indictment, but the time of this indictment and now. Okay, so obviously it would need to go back if he was in custody, but I would need documentation of that. And so I don't know if that's something you guys want to take into consideration.
And that's what my notes have reflected, the credit for the time that I was anticipating we would have had a hold, because he's been in custody at least 18 months now.
Right, which, I mean,
He's asking for.
he would have enough time under his belt. And I understand what he's asking, but I don't know if y'all want to visit about that.
I've explained.
Opportunity.
He wants an opportunity to do probation, so.
Well, that's between y'all then, and so
Well, it
then,
could be a-
all right, back to the bond,
It could be a
so,
gap, Your Honor.
look at one more thing real quick. I mean, I'm not, so here's the thing, he's obviously a convicted felon, picked up an unlawful possession of a felon over in Jeff Parish, picked up another one after that over here. So at this time, based on all of the information that I've received, again, from that public safety report as well as the criminal history, the facts of the case, I'm going to deny the motion to reduce the bond. You guys can visit about any options, and then we'll get it set for an announcement.
Yes, sir. I'll
right.
try to maybe figure something out.
All right, thanks. Good morning, sir. Are you Hakeem Thomas?
Yes.
And Mr. Thomas is charged in cause number 25 DCCR 0843 with the first-degree felony offense of aggravated robbery. And Mr. Lewis has filed a motion asking that I reduce the bond, which is currently set at,
600,000.
okay. And Ms. Malfino, you have a witness. Do you want Ms. Malfino to go first? Would you rather go first, or
No, I prefer she can go first.
go ahead, Ms. Malfino?
Okay, Judge, just for purposes of the record, I would tender to the court, just for ease of use, State's Exhibit Number 1, which is a probable cause affidavit in this case, and I would call Detective Kennedy.
I mean, it's in my file. Do you any objection
No
to,
objection.
States 1 is admitted for purposes of this hearing. Good morning, sir. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. Go ahead.
Could you please state your name for the record?
Dwight Dean,
And how are you employed?
Beaumont Police Department,
How long have you been in the city of Beaumont?
31 years.
You're a certified peace officer in the state of Texas.
Yes, ma'am.
And you and I discussed this case involving Hakeem Thomas as well as his co-defendant Tyree Hartley last week. And we're here in order to address the bond in this case. Can you briefly go over your involvement in the case and your familiarity with the facts in this case and why you think it's important that this defendant remains in custody.
My involvement is through Southeast Texas. I left that task force. We deal with auto burglaries. And a new offense, as was added to our penal code called jugging. We believe that this offense started out as a possible jugging on breaking into a car, which ended up into injury with two of the guys involved, one standing here as well, that ended up injuring an infant child through coordinated efforts of us locally here in Beaumont, myself, officers on the street, along with deputies of the Chambers County Sheriff's Department. We're all involved to have these guys arrested.
So they did actually flee from this jurisdiction into Chambers County after this offense, which again involved an infant child in the back seat of that car being injured when they attempted to break into that car and retrieve the money that the child's mother had obtained from the ATM.
That's correct. The ATM of the bank, that the vehicle, the dad left the vehicle, and the mother and the infant child were in the back seat of the car. Not only did they break into the car with shattering the glass on top of the baby and the mother in the car, with her continued efforts during the crime itself, they didn't stop. They kept on. Once they were successful, if you could say that, in any kind of theft, they did flee from here and were actually located found in the same vehicle.
And did you subsequently with Detective Andrew learn that both of these defendants in this case had committed similar types of acts in various jurisdictions across Southeast Texas, Harris County, Fort Bend County, Austin, etc.?
Yes, ma'am. Some of it did happen that actual day, and then of course some of it was put together, shredded background, and those are in that.
And is it your position, based on all of your years of training and experience as an officer here in Jefferson County, Texas, that to maintain the security and well-being of the safety of the citizens of Jefferson County, that it be best that pending prosecution of this offense, this defendant at least remain with some kind of a high bond from this court?
Yes, ma'am.
Thank you. I'll pass the witness chair.
Thank you, Mr. Lewis.
Yes, just briefly. Now, you said you were definitely part of the investigation of this allegation, correct?
That's correct.
Now, during your investigation, was it ever shown that a weapon or any deadly weapon anything was exhibited to the plaintiff witness? Or so there was no weapon involved as far as we know?
Not that I'm aware of.
Okay. And as far as your investigation as it relates to my client, was it any statements or evidence that showed that he was involved with the actual breaking of that of the glass or possibly injuring the child involved?
Not that I'm aware of.
Is there any evidence that would show that they even knew it was an infant child in the car at the time?
No, it's not.
Okay. I'll pass the witness, Judge.
I've done it for the judge's argument.
Thank you. Thank you, Officer Dean. So do you wish to call your client with regard to his financial status? Mr. Thomas, come back around. Best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, go ahead.
Mr. Thomas, as far as your financial situation, you're currently in custody, correct?
Yes, ma'am. Yes, ma'am.
Now, do you have any money saved up that could be used for your bond?
No, sir.
Do you have any property that could be sold or vehicles or anything of that nature that could be sold in order for your family to come up with your bond?
No, sir.
Who would be responsible in trying to come up with the bond amount?
My mother and my wife.
your mother and your wife. Have they been in touch with any bondsmen, currently? Okay. And from the information you received, how much of a bond or commitment they will be able to make to try to bond you out?
Complete bond amount, between 70 and 100,000.
Between $70,000 and $100,000. Okay. Now, were you employed before you came to custody?
No, sir.
Do you have any employment or anything available to you if you're able to make bond?
Yes, sir.
And what would that be?
Being a helper to my wife's father in his CDL truck.
Okay. And that will give you enough money to be able to take care of any pretrial conditions or anything you need to do
Yes,
with your representation at this case?
Yes, sir.
Okay. I pass the witness in regards to you.
Ms. Malfino?
Mr. Thomas, tell the judge a little bit about your criminal history, starting when you were a juvenile.
I have no juvenile record.
Were you in trouble as a juvenile over in Harris County?
No.
What about your theft, your state jail felony theft from a person, which is basically another way of saying,
That's
who
not
did you
juvenile,
wrong?
no.
Don't talk over, okay? Just wait till she's finished talking so the court reporter can take one at a time.
I don't know.
Where was that?
Ladies and gentlemen,
Go ahead, Ms. Malfino, you might want to read.
Your theft from a person, which is basically a robbery, where was that?
2021,
Where, in Harris County?
Rosenberg.
Have you been in trouble in San Antonio?
No, no.
Have you been in trouble in Austin?
I have a pending case in Austin right now
For what?
for a robbery.
Do you have any kids?
Yes, ma'am.
Someone would have done this to your wife and your baby would have been in the car. What do you think that person should get? Prison time?
I don't understand this.
I don't have anything.
All right, anything else?
Nothing else for this witness, Judge.
All right, you may make argument.
Judge, as far as this case goes, you've seen that it is charged as aggravated robbery, but it's one where we don't have a deadly weapon involved or anything like that. The biggest issue, I think, with this situation, of course, is my client does have some criminal history and lives out of county. I believe there's already some bond conditions in place for him to have the GPS monitor and be able to go to be in Harris County, come back, of course, for court and everything. We are asking for a bond in between $75,000 and $100,000. I think that, including with the GPS monitoring and everything, would be enough to cover, one, secure his return to court, and also, of course, satisfy any public safety concerns while these cases are pending. He does not have a hold from the case in Austin, because I believe he's still on bond for that situation.
I bonded out while I'm being custody.
Right. So he is on bond for that, so he will be allowed to be released. My understanding, there's not been a court date set up there. We don't anticipate that interfering with us here as far as any type of issues. And from
When did you make bond on that case?
July, sometime in July.
Okay,
I'm not sure the exact date.
okay, that's
sometime
fine.
in July.
All right, go ahead.
But from talking with his family, they have been involved with this case he has going on up in Austin, and that I think that actually will be resolved pretty quickly, and won't interfere with what we have going on here.
What, if anything, and Officer Dean may know about, I know you noted some other counties where there were some potential issues. Do you have any other information on those?
I have reached out to Fort Bend, Judge. I have had difficulty in getting a final answer. A charge looks very looming. How they initially filed them, I think one of the impediments that I'm up against is in Harris County, Fort Bend County, that surrounding area. They have dropped a lot of stuff down to some very low amounts of time. So it looks like if an initial charge comes in as an aggravated robbery, it ends up 6 months later as theft from a person in the state jail. So that's really the totality that I've been able to.
Do you have any other
obtain
additional
from the
information?
co-defendant.
No, ma'am, that's exactly what I was gonna say. It looks like there's been some initial charges that were actual aggravated charges that were bumped down.
Okay, all right.
And I would also ask if you would take judicial notice of his incident of behavior report.
I will. I also have, and I think you guys should have received 7 pages of incident reports from the jail as well, which obviously y'all know my thoughts on that. And so, anything else?
No, Judge, and the state does not object relief necessarily in this case, just not, I would ask that it remain in an amount at least above $350,000.
Maybe something was there.
And Judge, if I may, to the jail incident reports, I think those were like early on when he got into custody. Of course, Mr. Thomas did speak about those and how, of course, he should conduct himself out there, and I don't think that he has had any other issues since that conversation.
If your information whatsoever to support it, what's your order to that? This case began with a comment.
I guess my concern, and I understand from the probable cause that the allegation is that Mr. Thomas was the driver of the car, but I don't know that that makes it any better whatsoever, because it doesn't sound like there's any evidence on why he and Mr. Hartley were in Jefferson County, if they're from Harris County and that's where he's going to live, why they're in Austin, why they're wherever they are, other than to come into our county and break into people's cars or jug, which has become a huge issue. And so based on the evidence today with regard to this specific offense, based on the jail incident reports, based on the information received through, again, take judicial notice of the court's file, the magistration information as well, the fact that there is at least one pending case that is similar, others that sound similar, just with some different outcomes, I don't think it is in anyone's best interest that Mr. Thomas have any relief today, and so I'm going to deny the motion to reduce the bond. We will reset the case and for an announcement and see where we get. All right, thank you, sir, for being here, Mr. Kane.